Hi students, this week we're going to be talking about legal fees. Alright, as you recall from prior audios with the PowerPoint, you can read the goals and objectives for this chapter on your own. Alright, we're going to be talking about a variety of different types of legal fees. And some of these words will be new to you. Some of them pertain to legal fees but aren't actually a type of legal fee. Like a task-based billing isn't exactly a legal fee, but it's under that category. Okay, so in general, we are giving advice in law or we're drafting documents, and people aren't used to paying for those type of things. They're more used to going into a store and buying a tangible good. And so sometimes clients, if they get the advice, they decide, well, that advice wasn't worth it, and I don't want to pay. The problem with that is that lawyers have gone to, kindergarten, elementary, middle, high school. They have to have a bachelor's degree typically, and then they've gone to an additional 3 years of training. And that college and law school can cost around $200,000. So that advice isn't free, especially because the attorney, in order to give any advice, has to have legal malpractice insurance. Depending on how many years the attorney has been in business, what type of law they practice, whether they've had any legal malpractice claims against them in the past, that insurance can cost up to $75 an hour or more, depending on the type of law and the factors we mentioned a minute ago. So typically what attorneys have learned to do is they have somebody come in, they talk to them about their case, they assess it, they have them sign an attorney-client fee agreement, and they give them an estimate of how much they think it might cost for the work the client wants done. Depending on how much the estimate is, the client might pay it all up front, might pay some of it up front, but the point is the attorney needs to get some money as a retainer up front, so then as they do the work, give the advice, do the paper, they can then take the money out of the retainer. And this prevents the client from saying, well, I didn't really think that advice was worth it because I kind of sort of thought it was going to be that way anyway. That wasn't the deal. The deal was in the attorney-client fee agreement that the client was going to pay for this advice. So I understand it's contrary to how we think a lot of times, but you're going into this area of work, so you got to start adjusting your way of viewing it, because otherwise how are your bills as a paralegal going to get paid? Alright, so don't worry so much about the non-refundable chargeable and the refundable chargeable, because in San Diego, typically how it works is that anything, for example, if we get a $5,000 retainer and we don't do $5,000 worth of work, that would typically be returned to the client in San Diego. Only parts of the country, typically where they don't have as many lawyers, will they not refund that money. So California has some of the highest number of lawyers in the country, so we're pretty much going to be required to usually return whatever we don't actually earn. And that just kind of makes sense. Alright, so it's an estimate. So it would be based on how many hours of work the attorney thinks that the law firm's going to need to do times the hourly rates of the people working on it. In this case, it would be a $2,000 retainer. Alright, the most typical type of attorney's fees are hourly fees. And I've given you a supplemental PowerPoint as well, and I have a bigger graphic for you of this pie chart and the pie chart is of the 60-minute hour. And typically in San Diego, we don't charge in quarter hours. Some other parts of the country can get away with that, but in San Diego, we have a lot of competition. So we typically, anywhere from 1 minute to 6 minutes would bill a 0.1, anywhere from 7 to 12 minutes bill a 0.2, and so forth on up to an hour. And then once it's over an hour, it goes to 1.1, 1.2, 1.3. And it's one of the easiest ways to keep track of how much the client owes us. And it is going to be a different way of thinking for you again, because you're going to be having to keep a lot closer time than most of us do nowadays with our cell phones versus having a watch on. And is it really appropriate to be looking at your cell phone if you're with a client, that sort of thing. You're going to be much more in tune to what you're doing every hour of the day. And I like to call my watch my ball and chain, because I'm very cognizant at all times of how fast am I talking. Am I talking fast enough that I'm not overcharging the client? Am I talking too fast so that they can't understand me? Am I working hard enough and getting enough done? And really keeping track of every moment of my day and knowing where all my time gets spent. Okay, so these are paralegal billing rates across the country, and you can see what percent of paralegals across the country get paid this. And in San Diego, like I pointed out before, we really are at this $76 to $85 or $75 and starting and going on up in terms of the hourly rates that paralegals bill for in this town. Now, as we've talked about before, that doesn't mean that's what you will get paid. That would be what the law firm might get paid. All right, a blended hourly rate is not so common in San Diego, but we'll talk about it briefly just because it's becoming more common. Typically, an attorney is going to bill out an hourly rate higher than a paralegal because of more years of education. Sometimes, if it's a case where it looks like for every hour of attorney work, if a paralegal would do an hour of work, we might combine those two rates. In this case, $300 for an attorney partner, $200 for an associate, $100 for a paralegal, add up to $600, divide it by 3 for $200 an hour. But that isn't as common in San Diego. So what are the factors that are used in determining hourly rates? Typically in San Diego, we actually separately budget for expenses like mail, postage, and long-distance telephone calls, that sort of thing. So things that are more used, remember again, this is a national book, and I'm trying to teach you more San Diego and California specific, is how much profit does a law firm want? How much of its bills does it actually get paid on? Because actually attorneys versus many other professions get our bills paid a lot less than other professions. We have a very high cost of living in San Diego, so that would increase the billable rate. How many years experience do the billers have? How able is the client to go ahead and pay this bill? What's the area of law? And how expert is the attorney and how well known is the law firm? All right, the second most common type of attorney billing is a flat fee. Now, flat fees really are used for paperwork that is reused over and over and over, and then usually tailor-made to the client. So, for example, wills and trusts typically are very commonly charged as a flat fee because the attorney might use the same will and the same trust over and over and over and over again for each client, but then tailor it to the specific needs of each client. So it just makes more sense to do a flat fee and pay for that expertise in modifying those documents. Other examples you can read here as well. Now, typically an attorney knows, like for example, going back to the wills and trust example, if the client comes in, tells them what kind of case they have, the attorney knows about how long it's going to take them to prepare that will and trust. So then they can determine their flat fees based on an estimate. So it's kind of like a retainer almost, but it's earned once it's given. Unlike a retainer, where a retainer you have to earn the money and then take it out of the account, with a flat fee I can actually, typically what I do is I get half up front and half upon completion. And so once I get that first check, I can put it in my personal account, and that's not considered this legal term called commingling. I'm not supposed to commingle the client's money with my own, but with a flat fee I've already earned it because I have the paperwork already. And then when I finish modifying it, I get the second fee, and I can just go ahead and put it in my own account as well. Task-based fees are the least common, especially in San Diego. But some parts of the country like it, so I mention it. It would be per deposition. We're going to charge a certain amount for a deposition. Or drafting a motion, we're going to charge a certain amount for drafting a motion. So it's based on the type of work the attorney is doing, specific tasks they're doing. Now, contingency fees are very common all across the country, and they're really great in that they offer a lot more people access to legal services. So how it works is that the attorney would not get any money until the attorney wins the case. And then the recovery, or the amount of money that the attorney would get upon settlement or winning the case, would be usually about a third. That number can go up or down depending on the amount of work and when during the case the attorney settled. So, there's two different ways to look at contingency fees. One is to take the costs from down here, and one is to take the costs from up here. And because this one offers the clients a little bit more money, they greatly prefer the net fee method. Sorry. Important things to remember about a contingency fee. A 33% might sound like a lot, but sometimes the attorney loses the case and gets nothing. Also, that case might take 2 or 3 years to come to completion. And during that time, the attorney isn't making any money off of that case. Okay, so attorneys are allowed to split fees between themselves within certain parameters. However, attorneys are not allowed to directly split fees with paralegals. So if your attorney wins a case and says, hey, I got 30 grand and I'm going to give you 5,000 of it, that's a big red flag. Typically, it has to be done usually in a slightly different way to make it legally ethical. All right, so what are some other things that we charge for in law? We charge for support staff like legal secretaries. We charge for costs, things like filing complaints, serving complaints, research. We also try to recover some of the kind of more hidden costs, reoccurring costs like rent but that's harder to do. Okay, so this is the fee factors you're supposed to use for your assignment. You're looking at how much time is needed, whether the attorney can have done other work, what's the usual rate in that area, how much money is involved, how good a job does the attorney do, how fast does the attorney have to do the job, what's the relationship with the client, how experienced and able are the attorneys, and what kind of fee it is. So those are the factors that you're supposed to be using in doing your assignment. Okay, so a lien is usually in those contingency fee cases. So the attorney wins, the client wants to get paid, but what about the attorney? So the attorney usually has a lien on that contingency, on that settlement in a contingency fee case to make sure that they get paid. Okay, paralegals really, if they're going to go over the attorney-client fee agreement with the client, they need to make sure they stop and have the attorney come and review it again and sign it with the client. Paralegals cannot do that. All right, it is under Missouri versus Jenkins. This is a very good case for you to know. It is completely acceptable and allowed to bill an attorney's time, not attorney's time, a paralegal's time to the client. So what are things that you can do that are billable? And typically it's stuff that has to be supervised still by an attorney. You have to have sufficient qualifications, and Business and Professions Code 6450 in the state of California regulates paralegals. So you have to have 24 units at our school and before you can start billing, for instance. It can't be something just purely secretarial that you're doing. You have to bill a reasonable amount of time for what you're doing, not overbill. And that is it for that chapter this week.